Great. Good afternoon, everybody. It is great to have you. Thank you for agreeing to serve on what is our Senate Sexual Harassment Panel. I'm Allison Clarkson. Have been appointed to be the chair. And why don't we just go around and introduce ourselves? Allison Clarkson.
Brian Campion.
Andrew Kirkland.
Damian Leonard, Legislative Council.
John Bloomer, Senate Secretary.
Rebecca White, Windsor County, and Watson, Washington District.
Melissa Kasarek, Assistant Secretary.
And our fabulous
Lindsay.
assistant.
Yeah, Lindsay Schreier, Legislative Operations.
And Dave Weeks, Baldwin County.
So David is off camera and John, you are as well. So when you guys speak, if you'd be kind enough to just lean in so people can see you, that would be great. So we're convening for the first time for the 2023-24 biennium. And I thought Damien and I and Lindsay chatted about how, and John too, chatted about how best to get us going. And first thing is, I think, to be clear on what our charge is and what the jurisdiction of this panel is. And so we're going to do that. We are going to review the policy and the policy updates because the House has adopted the policy updates, which both the House and the Senate worked on last biennium. The Senate was poised to adopt them, and we ran out of time, is I basically think what happened. And John and Damien will fill us in further on that. And then we are going to just chat about the difference between policy and the procedure, because the policy can be the same between the House and the Senate. Very important, I think, to have consistency, as the panels in the past have felt. But the procedures, because we have a different system of operation, the procedures are different. So John is going to go over those. So that's maybe for our first meeting, and then maybe at our second meeting we can move to adopt and maybe do one or two more amendments of the policy that we have already updated. So Damien, it's yours.
Thank you. The panel is formed under Senate Rule 101. And that provides that committee on committees appoints you as soon as possible after the start of the session. And your authority is to receive, investigate, and resolve complaints of sexual harassment, retaliation, and non-compliance made against members or officers of the Senate. The President Pro Tempore is charged with ensuring that training is made available to all Senate members and employees, and that has been done already. And then ultimately the Rules Committee under the Senate rule is charged with adopting a policy and procedure for receiving and reviewing allegations. Although in the past, this panel has done the work of developing that. And then John can probably speak more to how that's been adopted in the past. Because I've only been involved in the work of drafting the language, not in the actual adoption. So to bring you up to date, in the past, at one point, the Senate and the House had different policies. The Senate and the House then worked together, came up with one unified policy. The House has since updated their policy, so we're again at a state where the Senate and the House have different policies. So last biennium, literally the last week of the biennium, there's 2 weeks ago, the House passed and adopted a new policy and sent it over to your predecessors, who had a chance to begin walking through that and begin asking questions about it, but never had a chance before the end of the session to actually complete their work on it. So I can bring you up to date on the old policy, just give you a walkthrough of that. I can talk about House policy, whatever works best for you.
I think it would be great. Maybe yeah, I think it would be great to look at it. You all got this at the training, so I assume you all at least have it. And we can also send around and I may go on we have a web page. So all the documents currently are on the web, on our Senate webpage and the House webpage. So I got there approved policy updates from the website,
Mhm.
but everyone can. Should I have that printed out for us? Wait, why don't you just walk us through?
Yeah, I can walk you through. So it's worth noting the House panel met this morning and we adopted their policy, which they're required to adopt it affirmatively every biennium.
It triggers a whole.
You'll be fine, Senator.
You'll be fine. Don't worry about it.
I have that.
Yeah, I got it.
Yeah. So your existing policy, if you look at it, the introductory language reflects that this is the old joint policy. It says, this policy has been adopted by the Senate and House and shall serve as the joint policy for both the Senate and the House. As I just mentioned, that's no longer the case. The Senate policy, is intended to regulate senators and Senate staff. It has also been adopted, as has the House policy, by all of the joint staff offices. So, and if there was a complaint about someone in, for example, office of the council or joint fiscal, the complaint would go to a joint panel composed of members from the Senate panel and members from the House panel. And there are also rules in the policy for what happens if there's a complaint by a senator against a representative or vice versa. Sexual harassment, the definition of that is the definition that we at this point can all be familiar with. It is unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature when submission is made either explicitly or implicitly to a term or condition of employment. Submission or rejection is used as a component of the basis for employment decisions affecting an individual, or perhaps most importantly for our work environment here, the conduct has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive work environment. It's worth noting the House policy has slightly different wording here. Their language is worded slightly broader and has gotten rid of some of the terms like unreasonably. So it suggests the effect of interfering with an individual's work performance. These were some of the issues that last year's panel was just beginning to consider. The policy goes on to describe that it may be verbal, physical, auditory, or visual conduct, or any combination, that it can occur between individuals regardless of their perceived or relative power and authority, regardless of their genders, their sexual orientations, and that essentially any person can be either a perpetrator or a victim of sexual harassment. It's also worth noting that often what we think of traditionally as sexual harassment is really where it's requests for sexual favor or sexual innuendo is a subset of sexual harassment. Sexual harassment is a form of sex discrimination. So any harassment that's based in sex can become sexual harassment. So that's important to note. So it can be comments about someone's gender identity or sexual orientation on a repeated basis can become sexual harassment. There are examples provided on page 6 of the Senate policy. I'm not going to read through them, but they include physical conduct, verbal conduct, various communications, use of names or vulgar jokes, etc. that could constitute sexual harassment.
Page 6 is
Page 2.
Oh, so it's page 2, page 2 of the PDF. I'm sorry. Thank you. I'm looking at the wrong page counter. So under the policy, individuals have 3 options.
Oh, yeah.
The first is to identify the objectionable conduct to the individual and ask them to stop. The second is to informally contact a member of the panel. And then the third is to file a formal written complaint with the panel. Individuals are not required to pursue those options in order. They can go right to a formal written complaint. They could begin the informal process and then decide to just speak with the individual directly. Whatever works for that individual, they're allowed to pursue. And in addition, individuals are allowed to pursue other avenues outside of the policy, which are detailed in the other resources section. These would include filing a complaint with the Human Rights Commission, hiring a private attorney to commence a lawsuit, things like that. The only exception in the policy to the sort of discretion about how to proceed comes when someone who's regulated by the policy witnesses or is made aware of sexual harassment committed against a person who is or appears to be under 18 years of age. And that's because of our concern for the well-being and safety of minors. And in that case, the individual who witnesses or becomes aware of it is required to immediately inform the chief of the Capitol Police and our sergeant at arms. Yes.
Are we as legislators mandated reporters?
Not that I'm aware of.
Okay.
The policy does mandate this reporting though for conduct within the state house, and obviously you all may have other requirements in your outside jobs. And so forth.
Yeah, you're a
So-
teacher,
Yes,
you're.
I am reporting that I was.
Exactly.
I believe that's what it means, well.
So, so I'm not going to go into too much detail on the language around identifying objectionable conduct. That's pretty self-explanatory. Informally contacting a member of the panel. The start of that is essentially a discussion of what happened. And under this policy, no action is taken without the authorization of the individual who contacts the panel member. There's an important caveat to that, which I'll get to in a minute. But if the complainant does not wish to attempt to resolve the situation informally, the panel member is required under the policy to take no further action and to inform the complainant that no panel record will be created or retained. If the complainant does give permission for the panel member to attempt to resolve the situation informally, the panel member would inform the rest of the panel of the incident, and then 2 or more panel members would meet with the individual who was alleged to have engaged in the conduct to attempt the informal resolution. The policy doesn't go into this, but sometimes an informal resolution, in my experience, includes both parties, with the panel members serving as mediators in the discussion. And it could incorporate, possibly if there's more than 2 parties, it could incorporate multiple parties there. And then following the informal resolution, the chair of the panel is required to promptly inform the president pro tem that there was an informal resolution, but to keep the identities and details of the conduct confidential. Other persons who are not a potential complainant, so they've not been the recipient of sexually harassing behavior or misconduct, can also contact a member of the panel. In that case, the next step is to then contact the potential complainant and discuss the incident with them, and again, proceed the same way. Let them determine whether to proceed. The important caveat here is there is potential liability that could attach if there's an indication that the behavior is likely sexual harassment and is likely to repeat. And under the employment law, employers are required to take immediate and appropriate action to ensure that the conduct stops. That puts you in a difficult position. I think in that case, the best way to proceed is to discuss the incident with counsel, Secretary Bloomer, or someone from ledge council and identify how to proceed. It's important to note Secretary Bloomer is the counsel to the panel. So he is your first line here for determining whether there is a reason to potentially do something in addition to try to protect the individual or prevent the behavior from continuing. It's also important to note that stopping the behavior doesn't necessarily, if the individual is afraid of confronting their harasser and does not want that to happen, there are many ways to do that by creating what's called a safety plan with the individual, where you can help ensure that they're not put in a situation where they're left alone with that person or in a vulnerable place. So there are potential options. And this is something that liability issue is something that we hadn't identified when we first adopted this policy. The House has addressed that in their new policy. It was one of the reasons why they opted to change it. But again, that's a
So
discussion.
we can
for
go
another
through that,
day.
I could go through the updates, because that's
Yeah.
one of the key areas that's been updated in. And also the addition of obviously a human resources officer, which we did not have when we originally wrote this policy.
Right. So the formal process here requires a written complaint that's signed by the individual filing it and submitted to any member of the panel. That's then passed on to the chair, and then the chair circulates it to the rest of the panel. It doesn't need to be any specific format, but it has to be signed. It can be written by or on behalf of the complainant. So sometimes if it's a particular traumatic event, the individual may have someone help them put their thoughts and recollection of the experience on paper. They just have to sign the complaint before it comes in to say, you know, this is my complaint and, you know, my recollection of events. It has to include a description of the conduct at issue and identify the alleged perpetrator of the conduct. And it can be submitted about a current regulated individual regarding conduct that occurred at any time during which the individual was a regulated individual. So that can stretch back years and in some cases decades in this building. I'm not sure how likely we are to have a complaint stretching back that far, but it is a possibility under the policy. With the formal complaint, again, there's prompt notice to the president pro tem that the complaint's been filed. And it does include the identities of the complainant and the regulated individual, but no description of conduct. That's another difference from the House policy at this point. Once the written complaint has been received by the chair, the following procedures are set out. So first, the regulated individual, the alleged perpetrator, is provided with a copy and they are allowed to file a response. The panel can then choose to take no further action on the matter if there's a related criminal proceeding going on. The panel can choose to wait until the criminal proceeding is dismissed or a decision no longer subject to appeal has been issued.
And the judge asked if the House change, well, I'm notifying the House Speaker, is that the part you said has changed?
Yeah, so the change in the House,
That's both.
yeah, the change in the House is that the identities are kept confidential until later in the process.
But you still inform them that there was a complaint, but no names.
That's right. And
Right.
the other thing in the House is they've broken their procedures and the policy into two separate documents. And they've now numbered their rules and procedures in part to save themselves from reopening the entire document every time they want to make a minor change. Because that has just been such a time-consuming process.
And also there's a limit to our having a uniform policy, which we really wanted because we all interact in this building in a way that made it sort of ridiculous to have two different policies. But the procedures are quite different in both bodies, which John's going to go through.
Right. Yeah, the Senate is a different body.
So
So
that was another reason to separate out policy and procedure.
There's a provision in here that prohibits any panel member who's a party to a complaint, as either the respondent or the complainant, from participating in any hearing. That makes sense.
Yeah.
The panel can also vote to prohibit a panel member who was a witness from proceeding or participating. And then if the complaint doesn't allege anything that's actually a violation of the policy, at that point, you're required to dismiss the complaint. You are allowed to contract with an attorney or another independent individual to investigate the complaint. We do have a law firm that is on retainer for our Human Resources Office that is also available to the panel to do that. Of course, the panel can choose to proceed with a different investigator or law firm, but it's Lindland, Blackman, Minitsky, and Burlington is currently retained to help out with employment and discrimination issues. And the reason we do that is because the potential for a conflict of interest if it was an internal attorney, so how small a building this is. Following the outcome, again, there's a determination on whether there's reasonable grounds to believe that a violation is committed. If there's no reasonable grounds, the complaint is closed, it remains confidential. If there are reasonable grounds, the panel can either issue a written warning, enter into a mutually agreed resolution, or set the matter for a hearing at which both parties would be permitted to hear the evidence and make their arguments, and then the panel would issue a decision at that point. If there is a hearing set, there's a prompt notice again to the President Pro Tem, which includes the description of the conduct at issue.
And the individual, right?
And the individuals actually with the written warning and the mutually agreed resolution, it also describes the conduct at issue at that point. There's a long description of how the hearings are conducted. The chair presides. You can have the attorney that you contracted with prosecute the charges, so essentially present the case against the regulated individual. The complainant and respondent are allowed to have an individual they're choosing to provide support. They can hire an attorney to represent them at the hearing. The joint panel would be 2 members from each of the panels, in addition to the chairs of the panels. The hearing is closed to the public unless the parties agree that it be open. You are not required to follow the Vermont rules of evidence. You can admit any evidence that's reliable, material, and relevant to the proceeding. The chair makes the evidentiary rulings, but she can be overruled by a majority of the remainder of the panel. Burden of proof is clear and convincing evidence. This is an intermediate burden, so it's not the criminal beyond reasonable doubt. It's not the preponderance of an evidence standard. It requires the evidence to be certain, unambiguous, and plain, and reasonable and persuasive enough that the panel believes that the conduct occurred. After the hearing, again, if you don't meet the evidentiary standard, you dismiss the complaint, close it. If you do, you can recommend corrective action at that point to the appropriate authority. And that's going to depend on who the regulated individual is. If it's a staff person, it would be their supervisor. If it is the Secretary of the Senate, it would be the appointing authority for the Secretary. If it's a member of the Senate, it would be the Senate Rules Committee or the whole Senate. And this is where Secretary Bloomer is going to be much more assistance to you than I am. So, and the potential penalties can include everything from counseling or training all the way up to something like censure or expulsion. And as you can imagine, the more significant penalties raise significant legal and other questions that the Senate Secretary would be best to deal with and address.
So, What's our time frame?
You know,
So
I
give,
look up five.
yeah,
I'm sorry.
Isn't the goal today, but what is the? How it
Well-
all seems up, because that's what happened last year. We kept not having enough time to have.
yeah, so we've gotten through most of the current policy. What, my guess is, do we have time before you have to leave? You have to leave and you have to leave. You have to leave how quickly? Because John's gonna do procedures.
I probably have to leave in about 5 minutes.
Okay, so why don't we meet again fairly soon to go through the updates that the House has proposed with their amendments. I know we are gonna have a few thoughts too on that.
Mhm.
In the 5 minutes we have left, why don't you give the new members a notion, because I think many, if not all of you are new members to this panel. Have you served before?
No, I am not.
Okay, so I think I'm the only one who's served before on
I
this.
served them.
Did you serve on it last biennium? So, would you give just a notion of the scale, of the scope of, how often have we had cases in the last, like, 5, 6 years? We
So,
didn't give people a notion of,
yeah, so I'm a little bit limited on what I can say, but,
There's the report that was.
there are the reports that come out, so each biennium or year the panel reports. I think the House panel has reported 3 informal complaints from last year. And all resolved in different ways. The House discrimination panel likewise had a couple of informal resolutions. To my knowledge, I'm not aware of any formal complaints that haven't been dismissed at the initial stage because they didn't actually state a violation of the policy. And in the Senate, I'm not aware of any.
we had
So-
one a couple of years ago.
Yeah, okay, so that was before I was staffing the panels. In the House, there was one in the discrimination panel, which was dismissed because it didn't state a claim under the policy, the panel had jurisdiction over, so. So there typically, my experience has been there are more questions that come up around the borderline behaviors that were talked about in the training, where you're not yet reaching the standard of violating the policy or violating the law. But it's conduct that's probably not appropriate for the legislative environment.
That's one of our gray areas, and one of the reasons, after we go through the updating and maybe adopting it, hopefully, and moving forward, that maybe we can discuss that, because I think that's in fact now that we have better training, there are still power dynamics in play, there is still inappropriate behavior, and the question is, it doesn't all just, it isn't all sexual. It isn't sexual harassment necessarily, but it is harassment, and it's inappropriate, and has impact on your performance. It has impact on your feeling comfortable in this building, which we want everyone to feel comfortable. And we want everybody, being as productive a legislators they could be. So that is, I think, something we want to explore and figure out what we want to do, and maybe if we, how we incorporate that in this panel's work. So with that, for this week, why don't I try and see if we could just next Friday, just meet again and go through the updates and get through those, because I think we should go through the updates before we, and there's, I know, some amendments to the updates too that we might consider. So you need to leave, and you have committee at 1, but if John could just go through the procedure,
Yeah, I'll go through.
the
5 to 10
differences
minutes.
between them, that would be great.
I will,
And maybe let's meet next Friday at the same time and go through the update.
Your email, Ernie, because it's not on our page, the new.
It's on the House Committee webpage.
we will get it posted because it was presented to you today, so we'll make sure it's on our committee page. Anything that was talked about today will move over, like just like it's a regular committee, we'll get it over.
And the updated policy from the House, which we are hoping will be a uniform policy, should be on the House
It's on the house.
website.
You're gonna put it on.
Yeah, it is on the House website. The only
I've got
thing
a
that
copy of
needs
it
to
here.
change in it is, the names of the panel members.
Yeah, this is from April, but it still does say things like unreasonably.
Oh,
It just saying.
okay, so it does. I thought that had been taken out on the House side. I may be thinking of their discrimination panel.
Yeah,
Sorry, I
so-
staffed 3 different panels, so I'm thinking on a little.
But if it's okay with you, we'll meet
Uh,
next Friday, same time, and we'll go through the update and maybe we can
Yeah.
even get to a document. So John, I know
5 minutes.
Damien has to go and
No, I'm going now.
Okay, I'll pick up with you. I want to actually give you at the end 3 things people need to think about before you two go in. Just-
David, you don't need to go for 10 minutes, do you? He's going, he's got to chair it, but.
I
Well,
Chair.
Okay, Robert, you here so we can see you. Damien, thank you.
Yeah, thank you.
I want to give you a little background. I talk fast and I'll try to cover 15 minutes worth of stuff in 10 minutes. I've got some. So generally speaking, back in 2018, in the spring of 2018, the joint policy was put together. House and Senate members got together. The House adopts policies by their committee. On our side, the Senate Rules Committee does. So there's a little bit of a different dynamics by our.
Yeah, we'll do the update and then it will have to be approved by. Senate.
And so then we met like a conference committee, even though there wasn't one, we put it all together. There were some critical areas that I want to highlight for you as you think even the next week about decisions you have to make. And there was that went through and it was agreed to by everybody in 2018. 2019,
I was part of that.
yes, 2019, the House, because they can change it by the committee, met in January. And they undid a lot of stuff. And so that began, and it was beginning to be looked at over here. It was sort of put on hold because they wanted to see how it was going to work. And the real dynamics there arrives because policies are schizophrenic, right? Because you're trying to cover different types of people. And so the major difference is you're trying to cover legislators and you're covering staff. And when you try to cover people in leg council, they're joint fiscal, it's a completely, in my opinion, different standard. And because there's a different standard, there's a tension into how you write that particular policy. And because we tried to do an overall policy, that there's different panels. If you look at the end, the Senate one deals with the Senate, the House deals with the House. There's joint panels when there's leg council, when there's joint fiscal, or some of the other organizations. Yeah, so there's a whole little table, and it becomes sort of, I say, it's like, maybe it's not a good term, schizophrenic as to how you deal with that. So what happened was, then Leg Council Chief of Staff, Damien went in and explained what Damien kind of talked about, how there's a duty or responsibility. So what do you do? And that's when they undid everything that we did in May. And then they adopted it, and then COVID hit. And then we came back last year and started talking about some of the changes. I think the thing you need to policies, Melissa and I have been working on this summer, we can get it real close. Procedures, there are some issues. The actual week you did a hearing, it's very difficult. I'll give you 1 or 2 quick things that you really have to be, you wouldn't want to adopt until you have now. You have to decide who drives the complaint process. Your current one has the alleged victim driving the complaint process. The new House one has other people driving. We can bring a complaint, it can go even if the alleged victim doesn't want it. You need to make sure which way you want that to be. And you can, in my opinion, you can have it either way, but that's the first decision on our side was sort of the alleged victim does it. This one is if somebody goes and makes a report, if it's clear that it's a sexual harassment, they have a duty because as an employment setting, leg council would. Joint fiscal would. Now there's a power dynamics and what should occur within the interactions between senators, or if one of you do something bad, it's a member of the public, and who should drive that. So that's
Or other offices within the building.
yeah. And so there's a little bit of a difference how you want to deal with that. And another one is who can complain or start with. That's whether the House one has any person can start the whole complaint process. As you noticed from Damien, it's the alleged victim can do it, or someone can go talk to a panel member, and then they can go talk to the victim. That's a distinction in the policy that you'll have to decide which way you want to go, because it is different. Let me find a little notes. There's really at some point you'll have to decide what you're really going to do. You're going to have a different procedure when it starts in the House. somebody at some point needs to address what happens on the joint committees. Because they're going to be different. And I'll give you an example which really worries us. The House member committee is 5 members. You have,
We've gone to 6.
they have
I
5.
don't know why. but
The
yeah.
decision trigger in the House is clear and convincing that both the victim had, if there is harassment, it has to be by at least 4 members.
They have to vote, 4 members have to vote.
Yes, or honestly, I can just have to go, 4 members have to say that they find it was not. There's no trigger on a 3. If you decide to do, they basically play, there's just some little, what I consider technical things. I'm not sure how they work through it. I'm not sure what it means, but the actual letters are, it's not the way committees usually function. The clear and convincing is used. If you look at our policy or how we go through our different policies, our procedures, ours are built on kind of legal standards. They've kind of done different stuff. You heard Damien talk about reasonable grounds. And the reason is because that's like whether a judge will sign it if it's there. They've used other terms. There's also some issues on who appeals. They actually appeal back to the same board. There's just some different sort of issues that if you want to go there, I'll draft it that way, but I want to make sure that you know where the downsides can be. So those are the areas I think you have to think about even this week. Is it any person that can complain and drive it? Does the committee start doing it by itself without the victims involved? There's also the new policy. They changed or tinkered with some language, which set up, I think, new legal standards. And we talked about that last spring. Damien asked, and I said, where is that the legal standard? He said, well, not really. And the issue is supervisors have to take action to stop it. It's not an actual legal standard because you never know somebody's going to do something completely insane. And so in that sense, our suggestion is as we rewrite the policy for you, we may put in what the legal standard is versus what the House did. I think that's a minor change. I don't think the House should have a big issue with it, but you can never guarantee something. And what worries us is if you say you're going to guarantee it and you don't, then you have a suit. Somebody's going to sue you. You're setting up a new legal standard that you may not be able to comply with, even if you're doing everything that's possible. So,
And if we're committed to stopping it, does that make us liable for years of therapy?
No.
I mean, I mean, how do we, that's a huge liability that we can't undertake.
so that is sort of my 15 minutes and a 10-minute. I believe we can get real close on the policies that applies.
Policy is going to be easier.
The building wide, the procedure is going to be a little bit more difficult to
So-
work through.
So for next week, for next Friday, maybe we should really take a peek at the new policy on the House website. Take a peek at our procedures, which are in the second half of this, right?
Yeah, and I will be honest, the policies aren't that much different. So the policy, they took the original policy with the joint one,
They
put it in a
tweaked it.
separate, and then they tweaked it. And
Yeah,
some of
but
the
it's a
tweaks,
good-
some of the
good
tweaks,
tweaks.
some of the tweaks are really good.
And like
Tweaks-
human resources office.
Well, they
They
did
do a bunch of stuff.
that and they elaborated on sexual harassment, what it can be
Yeah.
more inclusive. And so that's probably a good thing. And they did some punctuation things, but who knows what the right punctuation is.
That in the house are equal.
They can do it. Hey, that's not any of my issues.
That's not his issue today, which we do have different procedures. So I think we will reconvene next Friday at 12:15, go through the updates, and then begin our work on the procedures, which may be a little thornier and take us a little more time.
Motion to adjourn.
So I would entertain a motion to adjourn. Okay, great. Thank you, Lindsay, very much.